Well, friends, good morning. Jayendra Rana here. So, the topic of the day is legal environment of insurance industry. Legal environment of insurance industry. So, apart from the specific regulations or legislations relating to the insurance business, there are other laws which have a bearing on the insurance business, both life and non-life. These laws lay down the validity of contracts, the avenues for settlement of disputes between the contracting parties, and so on. So there are the Indian Contract Act affecting the insurance contracts as well as contracts with intermediaries, the Indian Stamp Act acquiring the stamping of policies, documents and receipts, the Exchange Control Regulations of the Reserve Bank of India as well as the Foreign Exchange Management Act dealing with the movement of monies across the boundaries of the country, and the Workmen's Compensation Act, nowadays it's called as the Employees Compensation Act, and Industrial Dispute Act, Shops and Establishment Act, etc., dealing with issues relating to the management of staff. Then the Consumer Protection Act 1986, which provides policyholders easy methods to get redress in case of deficiencies in services. So as far as the Motor Vehicle Act is concerned, the Motor Vehicle Act was passed in 1939. Chapter 8 of this Act, which was brought into force from 1st July 1946, provided that no motor vehicle can be used in a public place unless there is in force in relation to the vehicle a policy of insurance issued by an authorized insurer. So this policy is required to cover the insured's liability in respect of death or bodily injury of certain persons, for example, third parties, fare-paying passengers, paid drivers, etc., and damage to property of third parties. So the limit of liability is required to be covered are also prescribed in the Act. This Act was amended in 1988 and various provisions were revised, including attendant accidents, because there again the limitations of the compensation were revised. Then comes the Public Liability Insurance Act 1991. This Act was enacted in January 1991 to provide immediate relief to persons affected by the accidents occurring while handling hazardous substance. So an accident is a fortuitous, sudden and unexpected occurrence. A hazardous substance is as defined in the Environment Protection Act 1986. So a person other than a workman who suffers death or injury or damage to property is entitled to compensation under this Act. Owner of undertakings handling hazardous materials are liable to pay compensation under the Act. Owners are required by law to insure their liabilities. When an accident of the nature envisaged under this Act occurs, the collector of the district will invite claims for compensation. He will then decide on the amount of relief or compensation to be given. The limit of compensation have been laid down in the schedule. The next one is the Indian Steam Vessel Act 1917. The Indian Steam Vessel Act 1917. So the Inland Steam Vessel Act 1917, as amended in 77, provides for the application of the provisions of Chapter 8 of the Motor Vehicle Act 1939 in relation to the insurance of mechanically propelled vessels against third-party risks. So the Act makes it compulsory for owners or operators of the inland vessels to insure against legal liability for death or bodily injury of third parties or of passengers carried for hire or for reward, and for damage to property of third parties. So the limit of liability are also prescribed. Then there is the Marine Insurance Act 1963. So the Indian Marine Insurance Act 1963 is based on the Marine Insurance Act 1906, passed in the UK. Before the passing of the Act, the marine insurance was governed by common law. The Marine Insurance Act 1906 codified marine insurance law, comprising a large body of case law consisting of over 2,000 reported cases, spanning a period of 3 centuries. That forms the basis of present-day marine insurance law. So the important provisions of the Act relates to the indemnity, insurable interest, utmost good faith and subrogation and contribution, insurable value, warranties, types of losses, total and partial losses, etc., and measure of indemnity thereof, and return of premium. So marine insurance, being the oldest branch of insurance, its practice over centuries has been influenced by the various customs and uses. A unique feature of the Act is that while it states the law, it also allows the continuation of existing underwriting practices, conventions, etc. Some examples are: the Act provides for measure of insurable value but subject to any express provision or valuation in the policy. Thus, underwriters issue agreed value policies in hull and cargo insurance. The Act provides that a marine policy may be transferred by assignment unless it contains terms expressly prohibiting assignment. Thus, hull policies contain a clause prohibiting assignment unless prior consent of the underwriters is obtained. Then the next is the Carriage of Goods by Sea Act 1925. This Act defines the minimum right, liabilities and immunities of a ship owner in respect of loss or damage to the cargo carried. So the Act deals with 3 aspects of a ship owner's liability towards cargo owners. These are the circumstances when the ship owner is deemed to be liable for loss or damage to cargo, and the circumstances when the ship owner is exempted from liability, which when the loss or damage is caused by events outside his control like perils of the seas, and then the limits of liability of a ship owner for loss of or damage to cargo calculated in monetary terms per package or unit of cargo. The next act is the Merchant Shipping Act 1958. The Act also provides some protection to ship owners. For example, the liability of a ship owner can be limited to certain maximum sums for certain losses, provided the incident giving rise to such claims has arisen without the actual fault or privy of the ship owner. These claims may relate to loss of life, personal injury, or loss of or damage to property on land or water. So the Act makes it the obligation of the ship owner to send the ship to sea in a seaworthy and safe condition. The next act is the Indian Ports Major Ports Act 1963. This act defines the liability of Port Trust Authority for loss of or damage to goods while it's in their custody and prescribes time limit for filing monetary claims on or suits against the Port Trust Authorities. The next one is the Indian Railways Act 1890. So the Indian Railways Act passed in 1890 was amended in 1961, and the amendment came in force from 1st January 1962. Chapter 7 of this Act deals with the rights and liabilities of the railways as carriers of goods and procedures for notification of claims for compensation for losses. So the claims for loss or damage to cargo or person's death or injury is carried by the railways are adjudicated upon the Railway Claims Tribunal set up under the Railway Claims Tribunal Act 1987. Then the Carriers Act 1865. This act defines the rights and liabilities of the truck owners or operators who carry goods for public hire in respect of loss or damage to the goods carried by them. The Act also prescribes the time limit within which notice of loss or damage must be filed with the road carriers. Then the Indian Post Office Act 1898. This act defines the liability of the government for jobs, misdelivery, delays, or damage to any postal articles in the course of transmission by post. The next one is the Carriage by Air Act 1972. This act gives effect to the provisions of the Warsaw Convention 1929 and the Hague Protocol 1955 relating to international carriage of passengers and goods by air. This act defines the liability of the air carrier for the death of or injury to passengers and for loss of or damage to baggage and cargo, prescribes the maximum limit of liability for death, injury, damage, etc., and also prescribes the time limit within which claims have to be filed. So the provision of the act also apply with some changes to domestic air carriers operating within India. The next one is Multimodal Transportation Act 1993. This act seeks to regulate matters related to the transportation of goods from any place in India to any place outside India, using two or more modes multimodal of transport under a single transport contract. The salient features of this act are: those doing multimodal transportation business have to be registered. The multimodal transporter has to assume responsibility for the performance of the contract. Unless there is a specific reservation to the contrary, the transport contract will be prima facie evidence that the MTO had taken charge of the goods. The MTO is liable for loss of or damage to the consignment unless he provides or proves that there have been no fault or negligence on the part. So the liability for loss shall be limited to the provisions of the laws applicable in relation to the mode of transport during which the loss or damage had occurred. Stipulations in the contract to the contrary will be void. The MTO's liability is limited to the total loss of goods. Then Employees Compensation Act 1923. It came into force on 1st July 1924. The Act provides for the payment of compensation to workmen who suffers injury by accident arising out of and in the course of employment. Employees State Insurance Act 1948 is also there. The Employees State Insurance Act 1948 provides for the benefit to employees in cases of sickness, maternity, and employment injury. Under the Act, the Employees State Insurance Corporation has been set up to administer the insurance scheme. ESIC hospitals have been set up in many industrial areas, and workers get treatment and medicines at concessional rates. Both employees and employers are required to contribute towards a fund which is used to meet the expenses for various benefits provided under the Act of, including disablement and death benefits, medical treatment, establishment and maintenance of hospitals, dispensaries, and administration of the scheme. Then the Arbitration and Conciliation Act 1996 is there. This act, which replaced the Arbitration Act of 1940, provides for the settlement of dispute through arbitration. In arbitration, the dispute is referred to one or more persons selected by the parties to the dispute for a judgment. Arbitration is a recognized and valid process for the resolution of disputes and is commonly reported to because it is less formal, less expensive, and speedier than proceedings in a court of law. Lok Adalats are also helping in settlement of cases. And the next one is Consumer Protection Act 1986. So in the past several decades, there had been a movement to safeguard the interest of the customers. This has become known as consumerism and had developed as a reaction to business ignoring the rights of consumers and exploiting them. Issues of safety were raised, particularly in the case of motor cars. So under the Consumer Protection Act, a consumer is an individual or along with other individuals or through a consumer organization can approach the various forums prescribed under the Act. In order to attend the complaints under this Act, consumer dispute redressal forum are to be established in each district. So the forum at the district level will hear complaints at the value of 20 lakh rupees, and the forum at the state level will hear the complaints of 20 lakh to 1 crore. There is a provision also for the constitution of a national commission which will attend to matters beyond the jurisdiction of the state forums, and also the appeal against the decision of the state forums. Now this limit has been revised. So the Act provides for benches of the National Commission at various places and also for the circuit benches. Time limits have been fixed for admission of the complaints, issue of notices, and disposal of complaints. And the last one is corporate governance. So the expression corporate governance refers to the system by which the organizations are directed and controlled. That would include the structure, the distribution, of rights and responsibilities among the different participants in the corporation, like board, managers, shareholders, and stakeholders, and also the rules and procedures for making decisions on corporate affairs. It also includes the means adopted to achieve corporate objectives and to monitor the performance. So these are the few acts or the laws which are prevailing in the insurance industry today, because the last one has come into the operation is the Indian Information Technology Act 2000. This is also to control the technology related issues, because digital signatures are permitted and recognized by the law. Certifying authorities are appointed in India to validate digital signatures. Certifying authorities in other countries have to be recognized in India also. So the Cyber Regulatory Authority as well as the Cyber Regulatory Appellate Authority have been provided for under the Act. Appeals against the decision of the Appellate Authority can be made to the Supreme Court. So this is the legal environment prevailing in the insurance industry today. Thank you very much.